Good morning, everyone, and welcome to the 23rd meeting of the Justice Committee in 2020. Our first item of business this morning is a Stage 1 consideration of the Post-Mortem Examinations Defence Time Limits Scotland Bill. And I welcome our panel of witnesses who are all attending online. We're joined this morning by Gil Patterson, MSP, the member in charge of the bill, and Scottish Government officials supporting him, Andrew Milne, Liz Anderson, and Claudia Bennett. I welcome you all to our meeting this morning. And I invite, first of all, Mr. Patterson to make some short opening remarks in respect of his bill, and then we will move to questions. Mr. Patterson.
Thank you for inviting me here to say a few words on my bill. When a person dies in suspicious circumstances, post-mortem examination usually takes place within a few days of the death. There is also scope for a further post-mortem examination known as a defence PME, be carried out on behalf of the accused. There is no time frame in which this must take place or be instructed. In recent years, there have been high-profile cases where, due to delays in defence post-mortem examinations, relatives of murder victims, believed in the most distressing of circumstances, have waited far too long for the remains of their loved ones to be returned to them. One such case, and my motivation for bringing this bill forward, is that of Paige Docherty, the daughter of one of my constituents, who was murdered on the 19th of March 2019. Despite the suspect being charged within a week of her death, a defence post-mortem examination wasn't held until the 15th of April, and her body was not released to her family. It was released to her family on the 18th of April, 30 days after her murder. There was no transparency in the procedure, and this caused a great deal of distress to her family. My bill aims to lessen the suffering experienced by other families in similar situations by introducing an extendable 14-day time limit in which a defence post-mortem examination may be instructed. This will, I hope, reduce delays in the release of the body by encouraging the defence to act more quickly. It will also increase transparency in the system, helping families to understand what is happening, reducing the stress and giving them more advanced certainty about the timescales within which funeral arrangements can be made. Whilst the needs and interests of victims' families are at the heart of this bill, it also recognises the important role that the courts in determining the necessary timescales required to ensure a fair trial. That is why the accused can apply to the court for an extension to the time limit on an unlimited number of occasions, and provided an acceptable reason is given, an extension may always be granted. I thank the committee for its time today and urge it to give further consideration to my bill so that this important issue can be addressed fully.
Thank you very much, Mr. Patterson. That's a very helpful introduction. Can I ask if Andrew Milne, or indeed any of the other officials accompanying Mr. Patterson this morning, also wish to make any opening remarks? Mr. Milne?
No, thank you, Convener. We're happy just to go to questions.
Excellent. In that case, that's what we will do. We'll go straight to questions. So can I ask first, and I suppose the question is directed first at Mr. Patterson, but then Mr. Patterson can bring in officials if he wants. What general evidence is there? I mean, aside from the particular case of Paige Docherty that you've mentioned in your opening remarks, what general evidence is there of unacceptable delays in releasing the bodies of victims where homicide is suspected? How widespread is this problem?
I think it's fairly common. It would be my opinion on it. And there has been other high-profile cases after the Paige Docherty. And when you consider the number of homicides there is in Scotland, the fact that after such a short period, another one just as best described as bad as the Paige Docherty incident, then that tells me that, yeah, it's not uncommon. And but in any case, if it only happens occasionally and it can be prevented, then I think that's a good thing to do.
Yeah, yes, and I mean, I certainly hear the force of that argument. I'm just trying to. I mean, I don't want to talk about numbers because we're not talking about numbers. We're talking about people, but and families that are grieving in the most difficult of circumstances. But just so that we are clear of the scale of the problem, how many such cases are we talking about on an annual basis?
Well, I don't have that figure to hand. I would need to hazard a guess at it from when I started this in 2016, when I started, talking to all the folks that are involved in post-mortem. Then I would say it's probably about 10% of cases that cause concern, which is a fair order of number. But that's from my own experience. It could be more than that. The one thing that we don't know is that because there's no transparency, we don't actually know the number. And it's only when families go over and above what other families, some families may, and I'm only saying may, just put up with it. But when, in particular cases, when in the Page Doherty situation, which was a very poor, the death of Page Doherty was pretty horrific in itself, but the fact that this had dragged on the way it did, and because of their family wanting to have an open casket ceremony, and that was denied of them, so they became very vocal. And I know Sean Woodburn's family also did the same. These were two very, very high-profile ones. But the problem here is, to be quite honest, conveners, you don't know, because there's no transparency in this system at all. And my bill would introduce that, so we would all know what was happening all of the time.
Thank you, Mr. Patterson. That's very helpful. I'm going to turn over to Fulton McGregor now, and then after Fulton McGregor, it'll be Liam MacArthur. Fulton, please.
Hey, thanks, convener, and good morning, Gil. Can I firstly start by welcoming you to committee and commending you for the work that you've done in this area. I know how passionate you are about this and the work you've done, motivated by the tragic and awful circumstances that you described from your constituent. Following on from the convener, Gil, I wanted to ask a wee bit about if there's any evidence that the time taken for defence lawyers to decide in instructing a second post-mortem exam a contributor to any delays. Is that something that you and your team have found when looking into this bill?
Yeah. I mean, it's I've got my own views why what happens, but I just get the feeling in some circumstances there's no priority given to this because it's an open-ended procedure, so it's left, and I don't know. In no way, shape or form would I say it's deliberate. That would be impossible to think of that. But it may be that other things are involved by the defence, maybe very important things. It's somewhat left aside, and so the time elapses. So I that's the only answer I can give you to that one, Fulton.
Yeah, thanks for that, Gil. Is there any stats or figures on the number of times that the defence instructing a post-mortem has led to significant delays? Is that something that you've got any facts or figures on?
No, because again, you can't get your hands on them unless a family, as I was saying to the convener, unless a family decides to publicise it themselves, and that's not an easy job to do. if you think of the circumstances that they're in, they've got very important things to deal with. So there is no way of, there's no way you can go in and research and see it how long a particular defence is taking to come to that conclusion that they need a second post-mortem. And it's on demand. The fact that it's on demand means that there's nothing in law that says that it must happen by a certain time. And if it did, then, and some jurisdictions do actually say that the second, that there is a period that you can apply. The Scottish, as far as the one thing I have looked at very, very carefully, I can't find another jurisdiction in the whole world that automatically grants a second post-mortem. You've got to, every other jurisdiction, you've got to apply, and it's normally to the court or a judge that you've got to do that. Scotland's unique, that it's an automatic given that the defence will get one. Now, I'm very careful not to take that right away. That, I think, would cause a lot of barriers from the legal fraternity. So I'm not taking that right away. I think that right remains. It's just that there's a time frame of 14 days before the second one. It must be taken by 14 days. Otherwise, they need to apply to the court with good reason, and the court will decide whether or not a second one will be granted after the 14 days, that is.
Okay, thanks, Gil. That's helpful in setting out that context. Thanks very much.
Thank you, Fulton. I mean, just before I move to Mr. MacArthur, on the question of numbers, as far as if I'm reading it correctly, Mr. Patterson, the policy memorandum accompanying your bill says that there are something in the region of 60 homicides a year in Scotland, and that between December 2018 and December 2019, there were 182 post-mortem examinations carried out in Scotland, 182 in that year, of which only 2 were requested by the defence. So I don't know if that year is representative or unrepresentative, but that snapshot would suggest that of 182 postmortems carried out in a 12-month period, only 2 were requested by the defence. Any reflection on those numbers?
No, the one thing that I would say and agree with you is that very often the defence will utilise the Crown post-mortem. That which is a good thing, and that's quite common elsewhere. So that the numbers in relative terms that's a low number too. I think it normally is maybe about 10, somewhere between the 2 and 10 in an average year, but it's still a very low number compared to the number of postmortems, and I recognise that. If that is the case, and the numbers that go to a second post-mortem, then equally there's a higher number where the time taken is just too long, and this bill seeks to sort that out.
Understood. Thank you very much. Mr. MacArthur, please. Then after Liam MacArthur, it'll be John Finney. Liam.
Thanks, Camilla. Can I also start by commending Gil on his commitment to this issue and the efforts in taking forward a member's bill? I think not to be underestimated. So well done, Gil, on getting to this stage, and good morning to you. Just picking up the point the convener was touching on there in terms of the delays. Obviously, you set out the case in relation to the defence instruction of its own post-mortem. Though looking through the papers the committee's received, it would appear that there are other factors at play in relation to potential delays, such as identifying suspects, identifying even pathologists to be able to undertake these examinations. And I'm wondering what assessment you've done of the impact of those factors on any delays within the system.
Well, both my constituent and I recognise that there is a prospect, just for the very nature of a murder, that there may not even be an accused. So the bill doesn't. The bill starts when an accused has been charged and the defence appointed, and the defence sees sight of the Crown post-mortem, and then the 14 days start. So we don't criticise in any way the system in that it takes too long to charge someone. That's not where we're going with this. We recognise fully that it could well be the case that there is a significant, lots of good reasons why a second post-mortem can't take place, because there is no one being charged. So we recognise that. But all the reasons, so this is after the event that this bill, that's when it kicks in. It kicks in after someone has been charged, after a defence has been appointed, and after they have seen sight. Hopefully, when they look at the Crown post-mortem, and the convener alluded to it, then the defence decides we don't need a second post-mortem, and that's a good thing. This is related to the ones where a post-mortem takes place, and it's trying to tighten that procedure up, and that's what causes the problem. It's when a defence has been appointed that the problem starts.
That's helpful. I mean, I think the point you make about a reduction in demand for a second intrusive post-mortem because of the willingness of the defence to cooperate with or the Crown to cooperate with the defence in relation to the post-mortem seems to be in everybody's interest where that is appropriate. I suppose, and there's nothing really that can be done in terms of delays in identifying suspects. That will be a reflection of the nature of the case. But from your work in this area, is there a dearth in terms of the pool of pathologists that can carry out this work? I mean, is that an area that we need to be looking at in terms of bringing forward more people who are expert in this field and can carry out this work?
Yeah, I think. Again, I think you will see in the correspondence from people who raise a legitimate question that there's a shortage of forensic examiners. So that's not a reason. If there's a shortage at any given time in people available to do a second post-mortem, then that would be a legitimate reason to apply to the court for an extension, and that may happen, and we recognise that. But if there's a shortage of it, and we know about it, and I would say that since 2016, the very first interview I had I had a meeting with the Crown Office, and they raised that prospect that there's a shortage. And my answer to that then, and it's the answer now, if we all know there's a shortage, then that's what you need to fix. And it's not a good reason to delay, in my view, if we can look at that particular problem. And this bill, if this bill is enacted, and if perhaps the next post-mortem is delayed because of a shortage, then it will be highlighted. And then maybe, I'm not sure who's responsible. Is it the Crown Office or is it the government? Then I think quite honestly, Liam, that somebody needs to get their finger out. And if that is one of the problems, it's a problem that can be sorted. And we need more forensic examiners that can take care of that problem.
Thanks, Carl. I suspect it's probably the Crown Office responsibility, but with the resources provided by the Scottish Government. But that's very helpful in terms of clarifying it. Thanks, Convener.
Thank you, Liam. John Finney's next, please. John.
Thank you very much indeed, Convener. Convener, can I at the outset make a declaration as being a signatory of Mr Patterson's bill? That's the support that got it to this particular point, and like others, commend Mr Patterson for his diligence in this. I wonder, Mr Patterson, can I ask you, I'm aware of the length that of time that takes to get to this point. And very bluntly, I wonder if the purpose of your bill has been overtaken by events. And if not, if you could comment specifically, please, on a document published by the Crown Office in 2018, the Forensic Pathologist Consultation Protocol. Has that impacted on the purpose of your bill, please?
Well, first of all, Mr. Finney, may I say that I welcomed that, and how that came about is every step of the way. As I said, I interviewed everyone involved, from the police, the Crown Office, and the person that carried out the post-mortem, actually, in this case. And they were all sympathetic to me and in my ask. The one thing that I would say to you is that there is a general sympathy, and the reason that we have the protocol put in place in the first place is based on the work that I was doing, to be quite honest with you. Because every time I had an interview and a meeting, I would pass it on to the Cabinet Secretary for Justice, and he liaised with the Crown Office. And it was one of the people I was speaking to had raised the prospect of a protocol, and I flagged that up in the protocol, and I welcome the protocol. It's a good thing, and I think it will help the situation. But the problem with the protocol, it still relies in due diligence on the part of the defence. And if they have a slack day, then there's no sanction of any kind. And I believe that my bill makes the protocol work properly and brings it to its whole self. It gives the conclusion that is required in this case a successful outcome. The protocol is very good if everyone obeys it, but they should have been obeying it in the first place. They didn't need a protocol, in my view, in the past. Whereas my bill works really, it doesn't do anything to change the protocol. It enhances the protocol and it gets it where it should be. It puts a time frame in. The only thing missing in the protocol is a time frame. If we had a time frame in there, this bill wouldn't be coming forward.
Okay, that's very helpful and very clear. Thank you very much indeed, Mr. Patterson. Thank you, Convener.
Thank you, John. So far the thrust of the committee's questions has been about the problem which the bill is seeking to address, and I think we're now going to turn to a number of the detailed proposals in the bill itself. And Shona Robertson has questions about that to start with. Shona.
Good morning, Gil, and can I join with everyone in recognising the efforts? I know it's not easy to get a member's bill to this stage, so well done. You've touched on this already. It would be helpful to hear a little bit more about the relative advantages and the approach set out in your bill compared to perhaps other ways this could have been taken forward. You've obviously just been talking about the protocol. So what are the advantages in the approach in your bill?
The most straightforward advantages, if you can imagine, and it is hard to imagine, that the circumstances that victims' families are in, and the advantage is that they are left in many cases in the dark. No one can tell them anything when it comes to post-mortem. It is there's no transparency attached to it. You can find no numbers. The defence don't let anything out of their own sphere of influence. The police can't tell anyone. Nobody can tell anyone. And the one thing that it does, it introduces a straightforward transparency. People can then not just, it is as important to the general public that they also know what systems are. And I think we should be an open and transparent society. And something such as this, surely to goodness, we should be able to tell a bereaved family what's happening, where are we, what's the reasons. And that's the main factor that I see. The main advantage of this is bringing information to people that are really in distress. And if they want their loved one, their child, they want their child to bury their child. And so this allows that to take, it allows and lets them understand why the delay is taking place. So that's a very, very good thing.
Thanks, Gil. So just to understand, is that a requirement on the Crown to publish that information within the bill? Or is it to provide the information directly to the family? Can you just say a little bit about how that would work in practice?
Well, if there's a 14-day period, and the family will know that it is 14 days, and in the run up to the 14 days, and there will be good reasons that there may be a delay. There will be good reasons, and if that good reason is passed to the court, then that will be published. Then people will know they will know why it's going on for another 14 days. So that's the bit that's missing. I'm not saying that every step of the way and every day that a family should be informed. That wouldn't be practical. But when it comes to the key time frames, they would know it's 14 days and there would be an expectation. And if that was slipping for a good reason, then they would get to know that by the 14th day.
Thanks very much, Gil. That's really helpful. Thank you.
Thank you, Shona. And I think Rona Mackay wants to pick up a similar line of questioning. Rona, please.
Right. Thank you, Convener, and good morning, Gil. Gil, I remember this tragic case so very well, and I know how hard you've worked on it and your utter commitment to the family. It's really commendable. The bill would seem to me to be straightforward in its ask, not complicated. But can I ask you if any concerns were expressed during the consultation process and how the bill seeks to address these if there were any?
Well, the only real one that I could determine, and it's it may sound to folk illegitimate, was the one that I raised myself with you with the committee, and that is that the lack of forensic pathologists. Or a shortage at times, and that has created a difficulty. That is the one thing that has came forward that I think is of any substance, to be quite honest with you. I must say, in my deliberations with everyone, they've been wonderful with me and they understand what I've been trying to do. I've had a lot of help, to be quite honest with you, from all those involved. That's the only substantial roadblock to the bill that I can see, and I don't agree with it for the reasons I said earlier on, Rona. I don't think it's a good reason. I think that's something that could be easily sorted. So whether this bill fails or not, we should sort that problem out. In any case, we should attempt it. We know it's been going on since 2016.
You've clearly highlighted an issue there, Gil. So would you say that the legal profession in general were supportive of what you're trying to do?
Well, with that caveat, I think I wouldn't say supportive. I would say they were very, very sympathetic. They understood the torment that it was causing, and there's no question about that. And that came over loud and clear to me. But the one thing that was raised right at the start, and any legal objection, is about the shortage. It's not about anything else. It's not about denying the accused. Nobody said that this bill denies the accused of the right to a fair trial. Nothing like that. There's nothing in the law sense that people have come back on me at all. You won't find it, because I haven't found it. That's one element of it. That would you say it's legitimate? Yeah, it's legitimate if they have a concern, and it should be addressed one way or another.
Okay, thank you. That's interesting. Thank you.
Thank you, Rona. Okay, I think Liam Kerr, and then after Liam, it'll be Annabelle Ewing. So Liam Kerr, please.
Thank you, Convener. Good morning, Gil. I'd like to look at the 14-day time limit which I understand is extendable if the defence applies, and as you say in your opening remarks, if an acceptable reason is given. The actual bill says on cause shown, I think. Are you able to give the committee any examples of what might constitute an acceptable reason, or what might be cause that would justify such an extension?
Yeah, I think so. If you can imagine, let's say there was multi people accused, there may be a reason for to get some forensic evidence on who was in the location at the time that was missed. The one that's definite is if there's a shortage of forensic pathologists to examine, then that's legitimate. If I was a judge and I was asked, for instance, and although you see how passionate I am about this, I would grant it. So there are legitimate reasons. So multi-accused, one that I think would be legitimate, or if something was challenged, if someone said I wasn't there and somebody went back for some reason to look for some genetic evidence, it could possibly be a reason. But the good thing is, again, a judge would know about what's missing from first post-mortem, and it may already be there, and so maybe the judge would say, well, that's not sufficient, but other reasons that I've given, well, I would think these are legitimate reasons that would be extended.
Thanks for that, but that would be an acceptable reason then. But you said in your opening remarks that an application can be made any number of times, but actually the test, the initial 14 days, the initial period's passed, one requires special circumstances to get a further extension. In your view, is the acceptable reason and the special circumstances, are they the same thing, or a special circumstance different?
No, they're the same thing. Good reason would be, a good reason would be sufficient, because the one thing that the family that I'm dealing with, and I'm sure it's the same with every family, the last thing that they would want would be that an individual, the wrong person was charged, and because they weren't able to present all the evidence, then the idea that someone would still be at large that committed a murder that's the guiding factor here. So they want the opportunity for the defence to conduct its business properly. That's for sure.
Which makes sense. And the question that therefore kind of plays in my mind, Gil, is that if an extension can be granted on any number of occasions, as you said at the start, and on a relatively low threshold, because as you say, justice still has to be done, is there a risk, do you think, that actually this won't achieve any greater certainty about the time limit? Because, in theory, someone can come back any number of times and make further extension applications, and the interests of justice, if I may put words into your mouth, require that extension be given. So is that a risk, that lack of certainty?
No, I don't think so. And what I would say to you is, if you look at all the other jurisdictions that are there, and if you look at the time periods there, some are granted and some are not granted. So, case study tells you that they won't always be granted. So I would suspect in the Scottish situation the same thing would happen, that a judge would say, or a court would say, no, because here's the reasons why. Here's good reason why we're going to grant this extension. And the one thing is that the one thing everyone else has got is certainty. Everybody knows what's happening. Ours we don't know. That's the main thing we get out of this.
Thank you.
Thank you
Thank
very
you.
much. Thanks, Liam. Annabel Ewing, you've been waiting very patiently. Annabel, please.
Thank you, convener, and good morning to Gil. I would also declare an interest in that. I was happy to be a signatory to the proposed bill when it was initially put forward. I think we've had a very interesting discussion. Obviously, I think each of us has enormous sympathy with the reasons why Gil has brought forward this bill. Enormous sympathy. I'd ask to seek clarification as to what kind of discussions in general Gil has had with the Cabinet Secretary and indeed across parties to ascertain the likely level of legislative support for the bill. Thank you.
I'm not sure. I'm always happy. I've been at this game too long, and that's what my family tell me. The fact that I haven't had any real pressure or chat in regards to we think this is a bad idea and we can't support you in terms of the government, I haven't had that. I've only had encouragement, but I'm not sure. I'm not sure exactly what they think about this. But the fact that we're in politics, aren't we? The fact that nobody's tapped on the shoulder and told me that I don't think we can support this. I would say to you that particularly most of my time engaged in this, gathering my own evidence prior to launching the bill, which was extensive, and cooperation and dialogue with Michael Matheson was excellent. It was very, had a good listening ear. And it was very, very helpful to me. So, in regards to the government, maybe neutral would be the word I would use. Maybe a bit better neutral, but neutral would be fair, I think.
I thank Gil for that answer. I just wondered then, in terms of the opposition parties, if there's been any feedback on a group basis as to the likely position they will adopt?
No, nothing. Again, some colleagues that I've known, and spoke to, they've been very, very individually, members from different parties have been very supportive of it, spoke highly of its intention, thought it was a simple bill, not too complicated, didn't challenge the system. So I've had personal, it's not the way I do business anyway, to be quite honest. I don't really talk to parties as a group. I normally talk to folk that I know and trust their word, that if they tell me they think it's a good idea, it's good, honest consideration of giving and advice they're giving to me. That's just how I am, I'm afraid. So I don't know about parties. I have no idea.
Okay, thank you very much for that. Thank you, convener.
Thank you very much, Annabel, and thank you to all members for those questions, and thank you especially to Gil Patterson and to the officials for joining us this morning. No other member has indicated that they have any further questions on this bill. What we're going to do is that next week we're going to take evidence from Claire Baker, MSP, about her member's bill, and then we intend to discuss our approach to both bills after that. So we'll be in touch in due course, Mr. Patterson, to discuss our plans after we've heard from Claire Baker and had time to reflect on her bill as well as yours. But thank you very much indeed for joining us this morning and sharing with us your concerns about this matter. Thank you.
Could I have an ask of the committee and indulge the committee for a second?
Please.
Yeah, I know that the committee is extremely busy caused by COVID, and I know that it's got an enormous pressure. And I wonder if the committee would consider to ask the government and the Crown Office exactly what they think of the bill, And now I'm going to be really cheeky. And if there's a prospect of the Parliament deciding that the election's going to be delayed, and that it may be a short, a very short chance of that. But if it happened and the committee thought this was a worthy bill, would they consider holding it in the shelf just in case there's an extension to the Parliament? It's a simple, straightforward thing. And I wonder if the committee, in my absence, may consider that. I'm being very cheeky, but my age allows me to do that.
Well, Mr. Patterson, with great respect, I don't think it's got anything to do with age, but these are matters which are a long way above my pay grade. Delaying parliamentary elections is not a question for the Justice Committee, and not even a question for the convener of the Justice Committee. But we will take all of that on board. I assure you, we'll take it all on board, and we will consider what we can do with regard to this bill after we've heard from Claire Baker next week. But thank you very much indeed for joining us this morning and sharing all of that with us. We're now going to move on to the next item on our agenda, which is consideration of a legislative consent memorandum in relation to the United Kingdom government's sentencing bill, which I have not read, but I understand is 600 pages long, which is why I've not read the United Kingdom government's sentencing bill. We have a paper from our clerks summarising the relevant provisions of the bill and the legislative consent memorandum in the Scottish Government's name, and I'd like to ask if members have any comments on the legislative consent memorandum. If they do, could they indicate in the usual way on Blue Jeans? No member is indicating that they do have any comments to make with regard to the legislative consent memorandum. So if I'm right about that, and no members have any comments to make, are we agreed that the Scottish Parliament should give its consent to the relevant provisions in the sentencing bill? Members are agreed. Are members content to delegate to me the publication of a very short factual report on the outcome of our deliberations on this LCM today? Members are agreed. Thank you very much. So we can move straight on then to the next item on our agenda, which is consideration of subordinate legislation. And we have in front of us a negative instrument this morning, the Prison and Young Offenders Institutions Coronavirus Scotland Amendment Number 2 Rules 2020, SSI 2020/264. And again, we have a paper from the clerks summarising this SSI. Do members have any comments to make on this? It's a negative instrument. Do members have any comments to make on this instrument? No member is indicating that they have any comment to make. So are members content formally not to make any comments to the Parliament on this SSI? Members are content. That concludes consideration of SSIs, and indeed that concludes the public part of our meeting today. Our next meeting will be a week today on Tuesday the 6th of October, when, as I said a few moments ago, we will hear from Claire Baker MSP in relation to her Culpable Homicide Scotland Bill, and we'll consider our approach to the Hate Crime and Public Order Bill. We'll also look at a draft report on the Defamation and Malicious Publications Scotland Bill. So we'll move now into private session for the final item on our agenda. So members should please disconnect from Blue Jeans and move straight back into Microsoft Teams. Thank you very much.